Lauren Vázquez is the fired up lawyer. She is a cannabis business attorney and social entrepreneur who has worked for over a decade to end cannabis prohibition and advance alternatives to the failed war on drugs. Lauren has practiced cannabis business law since 2009 and entered private practice in 2011. She has advised numerous cannabis companies and organizations, and Lauren is also the chair of Oaksterdam's legal department and previously served as the National Deputy Director of Communications for the Marijuana Policy Project. In 2016, Lauren was a senior advisor and statewide organizer for the successful Prop 64 campaign that legalized cannabis in California, and she now assists cannabis businesses with licensing and the critical regulatory compliance and enjoys helping people achieve their cannabis dreams. Please welcome and take it away, Lauren Vázquez.
So we're going to jump into the U.S. legal system, um, federal, state, local, and the tribal governments. Going to touch on local real quick just to get it out of the way. This is where the rubber meets the road. All politics is local. This is where you have to extensively get involved and make a difference at the local level. You're only going to get what you advocate for. So this is where it's at, because the local government, they're always going to have the authority to ban cannabis businesses. That's just a general right that they have on regulating businesses. It's important to know what jurisdiction you're in and who has that authority. So, in California, we have cities and counties. Other states have cities and boroughs, villages, townships. But it's important to know which jurisdiction you're in. When you're dealing with cities and counties, the way that they're structured is that there's a city, and then it has its official city limits, and then outside of that is the county, and it has its official county limits. The area within the city, only city law applies regarding cannabis. In the areas in between, only the county rules apply. So you need to know, because if there's a ban in the city, but you're in the county jurisdiction, then you're okay. But if you're in the city and the city bans cannabis businesses, even if the county allows them, you're not okay. So whatever state you're in and whatever structure you're dealing with, make sure that you're dealing with the right authorities for where you want to be operating your cannabis business. The local government, they're also going to be able to decide the cannabis license types, how many they're going to give out of those licenses. Some local governments will put a cap, only 5 retail licenses. Some won't. Anybody who applies and qualifies can get a license. And then obviously some say 0, but it doesn't really make any rhyme or reason on how they choose to do this, because um, some cities will say that cultivation's, oh, that's the big bad wolf, and other cities will say, oh, we like cultivation because you can put it in a warehouse and nobody needs to know it's there. So whatever it is that you want to do, you have to advocate for. um, and the way that this is regulated generally is two separate sets of regulations. A lot of people only look at the municipal code, which that's the set of normal laws for a city or county. But there's also a zoning code, and zoning codes are specific to what can be done where. And so this is how we keep housing separate from industrial uses, and how we keep schools away from cannabis businesses, unfortunately. So you're going to need to be familiar with both the municipal code and the zoning code. The zoning code is going to determine where the cannabis businesses can locate. And even if a city doesn't have a cap on the number of licenses, if the zoning rules are too restrictive, that in effect creates a cap and limits the number of businesses that would be allowed. So you want to make sure that zoning regulations are not too restrictive. Sometimes they get a little out of hand, because things that are included in zoning are setbacks, like distances that you need to be from so-called sensitive uses. So things like schools and parks and senior centers, and that list can go on and on and on. And then setbacks would be distances from the property next door, or distance from other local cannabis businesses. So you can see how with these restrictions, it's also going to seriously limit the number of businesses that can be located in the city. Um, yes, and so once the um, city decides, yeah, we're going to allow cannabis businesses, they're going to set up an application process. They're going to set up a cannabis program. It's going to include local fees, application fees, licensing fees, perhaps even more fees. Also, local taxes are often implemented. And then, in addition to those local costs, we have local social equity programs, hopefully to help you pay for those costs. I know a number of you guys are social equity applicants or licensees. And so I bring up social equity in the local section because in California, that's how we got started, and that's how social equity got started. Although I will give credit to Massachusetts for doing the first state program, but it didn't even really come into thought because we were so eager to just get people out of jail and to make cannabis legal, get it out of this gray area that we were dealing with under Prop 215, that social equity that was much more advanced than where we were at that time. So the first to implement it was the city of Oakland at the local level. So Oakland has a program. If you qualify as a social equity applicant, meaning you can show that you've been harmed by cannabis prohibition, which most people have, but there are some set standards. Every state, every city and county is different. It often is your income, where you grew up, where you went to school. If you're currently low income, different uh, cate- categories like that, requirements like that. And if you do qualify, then you're eligible for certain advantages when it comes to licensing and the application process. You're eligible for grants and funding and support. And some of that support includes education, which includes Oaksterdam. So we've been involved in providing those services for a number of equity programs, both local and statewide. So there's a lot that you can get out of being a social equity applicant. It's not a perfect program, but the intent is to help people. And I think that we are doing that. First, we have the legislative branch. This is Congress, and they write the laws. So they unfortunately are the ones that first created cannabis prohibition. Thank you very much. Um, and when they write the laws, they write in how the law can be enforced. And that has been good for cannabis because some laws have been passed that restrict the way that it can be enforced. So we have the legislative branch, they write the laws, the executive branch enforces them, and the judicial branch determines if the other two are doing their job correctly, whether or not they're acting under the Constitution, and if what they did is unconstitutional. So while they've, we have federal prohibition, cannabis is illegal. We do have two laws. Well, one that protects us right now, and one that hopefully will be passed. We'll see. These are funding restrictions. So the Rohrabacher Blumenauer Amendment, passed a while ago now, a decade ago, it restricts enforcement of federal cannabis prohibition by the judicial department in states where medical cannabis is legal. So basically, that means that they can't have staff work on putting medical cannabis businesses in jail. It takes funding to have your prosecutor bring these charges and cases. So there have been cases that were dismissed on motion that the federal government was prohibited from prosecuting. And so that has been a very good protection. It only applies to the Justice Department, so not the, for example, IRS. We'll see how that comes into play. And then we would like to expand it so it applies to all state legal cannabis. And that would be the updated amendment, Blumenauer, McClintock, Lee. These folks, these names, they're all the Congress people that supported it. And so, they are from California, Oregon, Washington, D.C. These are folks that states that allow it, and this is in our interest to do this. The names will be changed because some of these Congress people have moved on, but that's where we're at when it comes to federal prohibition and what the Justice Department can do based on what Congress said. as far as enforcing the law. So it's a not a total protection, but it's a lot better than nothing, and was quite a big deal when that came out. So um, our constitution, it puts limits on each of these branches and what they're allowed to do. So Congress, the legislative branch, their powers are very specific. This is because when we founded our country, we wanted to have avoid a strong centralized power like a monarchy, and we wanted to make sure that the federal government was not overly powerful, and so the states were the ones that were given the purview of regulating and legislating most things. So the federal powers, they are specific, they are listed. And if they're not listed, then all the other powers are reserved to the states. This is what we hear about, states' rights. This is what that means specifically. So, what are the enumerated powers? There are all the things you would normally think about with the federal government. So, mail, money, taxes, wars, immigration, and tribal relations. So these are the areas that the federal government is more than allowed to create laws regulating and even prohibiting. So, in addition to those powers, one of its listed powers is to regulate interstate commerce. And this is a your first introduction to how the laws can get very convoluted, and what courts say doesn't necessarily make sense, but it is the law. And so the Interstate Commerce Clause allows the federal government to regulate anything that's going to affect commerce that crosses state lines. Now, back in the day, in the 1800s, hardly anything crossed state lines physically or virtually. We didn't even have telephones. And now, interstate commerce in the digital era, everything is interstate commerce. But it didn't take until modern times for this power to be expanded. It was early in the days. This is the Law School 101 case. It's about the wheat. There was wheat, and there was a farmer, and he was growing wheat, and the feds were regulating him. This is the early 1900s, and he wanted to know, why do the feds get to regulate me if I'm growing wheat and I'm only selling it within my state? Get out of here. And that was the first case to really expand the powers by saying, when you grow wheat, even if you're not selling it across state lines, you are having an effect on interstate commerce. You're affecting the market, you're adding to the supply, you're affecting the prices. And so, yeah, the federal government does have the right to pass laws regulating the growing of commercial wheat in his home state. So many years later, 2005, oh my gosh, 20 years ago now, but almost 80 years or so since that first case, we have one of the most recent cases, which was established based on cannabis. So this is a Supreme Court case, Gonzalez v. Raich. It is defines the interstate commerce powers, not just for cannabis, but for all of federal matters, and basically reiterated the same thing. These two women, Angel Raish and Diane Monson, they are medical cannabis patients. They are activists. They are well known in the cannabis movement. And back in the late 90s, they wanted to grow cannabis for their own medical use under Prop 215 in California. And so they sued the federal government, saying that the federal government did not have the power to regulate them. And what happened was the Supreme Court said, yes, it does. Exactly what they said before, that when you grow cannabis, even if you grow it for yourself, your own personal use in your home state without crossing state lines, you're not selling it in any way, non commercial. That is something that affects interstate commerce, and therefore the federal government can legislate it, and therefore federal cannabis prohibition is constitutional. And so, unfortunately, that's what we're left with today. Interstate Commerce Clause allows prohibition of inner state home protection. Home production and use of cannabis. So this is a major Supreme Court case, and unfortunately, we lost. So, like I said, one of those laws that Congress wrote is federal prohibition. All marijuana is illegal, so just get that into your head. But again, the law is convoluted. So, what does this mean? Well, it does mean CBD is illegal. It does mean that you have no defense. We did try to challenge this in the Supreme Court. Once again, United States versus the Oakland Cannabis Buyers Cooperative. Quite a while ago now. This case was fought by one of Oaksterdam's own, one of our founders, and the husband of Dale Sky Jones, Jeff Jones. And he fought the case, um, arguing that there's a medical defense under federal law to distributing cannabis to sick people who would otherwise die. And unfortunately, that case lost as well. But that was a huge effort to undertake back in the late 90s. And maybe you guys are kind of figuring out that the late 90s and early 2000s was a big time for legal pushes to challenge cannabis prohibition, and a big reason of why we're here today. Even though we didn't win, it showed that we were ready to fight back, and it just propelled the movement in a way that built the momentum that we needed. So, what is this marijuana? It's spelled with an H. That's confusing. Why? Well, it's because that's how Congress decided to spell it back in the day without bothering to check. So, it is defined very specifically under the law. And to simplify it, marijuana that is totally legal is all cannabis except hemp. Now, this is why we have a giant legal hemp market in the United States, because it is not marijuana and it is therefore legal under federal law. So, what is hemp? Well, it's cannabis that you can show has less than 0.3% THC, not more than. And what does that mean? It means it's, that's the potency, it's non intoxicating. And that is from the plant. We're growing the plant, it's a hemp plant. And then you are taking the flowers from the hemp plant. You're not growing THC flowers and then saying, hey, look, I grew this plant, it's less than 0.3%. You'd also have something really going on. That'd be a problem. Um, so, if you grow hemp and you get a harvest flowers from it, or you produce products from it, as long as it does not exceed the THC threshold, that is legal under federal law. Now, there is some restrictions. There are some USDA rules, and you do need to comply with your state hemp program in order to legally cultivate and have commercial hemp. So you've got to be aware of those restrictions. But to compare to the uh, prohibition of THC cannabis, it's a world apart. So, up until 2018, this loophole was really being exploited and abused, and people were saying that CBD was legal in all 50 states because it's from hemp. And if you, there you go. No, it's not legal in all 50 states even now, because you got to have state laws. You got to look at those. But also, up until that time, it did not include any extracts from the plants. So in 2018, we had another federal spending bill. It's called the Farm Bill. It's a bill that Congress passes over and over. It's reissued so that it regulates, just like it says, all of agriculture, basically. And in there, it defines hemp. And in 2018, all they did was simply change the definition of hemp to include extracts from the plant. And so that legalized CBD from hemp under federal law. Um, and so it doesn't include synthetic derivatives. Some Delta 8, THC, and other things cannot, they're not legal because they were not extracted from the plant. If they're synthesized, then that's not legal. That's illegal marijuana with an H. So we have seen a lot of ingenuity where people have just come up with not just hemp products, but developed novel cannabinoids, and it has exploded in a way that I never would have expected. Um, Thanks, Joey, for addressing Jackie's question. Industrial hemp is basically the way that the government would determine it's different than hemp that you're going to ingest. So, versus foods, industrial hemp's going to be for commercial purposes. Other hemp products are for consumption, human consumption.
And
So
this is part of what makes it so dangerous is people were purchasing industrial hemp and then extracting it and then giving it to like small children for medicine, but it's a bioaccumulator. You're going to learn a lot about this next week. It's not the same thing. So I'm really glad that you took the moment, Lauren, to underline ingestible for human consumption versus
I do also want to address the comments about the IND program. This is a program that the federal government used to have where if you were sick and the medicines you needed weren't quite FDA approved yet, you could have access to those. It was very tough to prove. It was part of the AIDS crisis to address that, and cannabis was included in that. And what that means is that the federal government at the University of Mississippi started a medical cannabis program in in the 80s, technically through today, where they grow cannabis and they roll it up and they send it out to the approved IND patients. At one point, I think the total number of patients was, I mean, less than 20. And unfortunately, most of them have passed away, and we still have one surviving. I think is it Irv Rosenfeld.
yeah, he is the last who's still on the receiving the medical cannabis that is, by the way, sticks and seeds and mold and years old, and it's not good cannabis, despite the fact that they
I
cook
hope it's improved. I hope it's improved over the years, but this program is
it
still
not.
run. This is where the government, the federal government, grows cannabis that is going to be used for research purposes. So when you hear about the federal marijuana program, this is what we're talking about. This is the biggest level of hypocrisy that I've ever heard of, maybe in all of existence of government. But excuse me, I'll step back and
It was
I'll
set up
repeal that
to limit.
statement when I'm talking to a group of Indian students. But the fact that the government puts people in jail for using a plant that they grow for other people is it's pretty disgusting. So I'll get off my little tangent, my little soapbox there. Oh, LV is LV not in the
Elvie's
program?
still alive. She has just exited the program because she
Got
can
it.
get much better cannabis in Oregon.
Whatever she wants. LV Musaka, you can Google her. She's one of our heroes, matriarchs of the cannabis movement. Um, we're talking about federal law. How does it work? Well, we have the Controlled Substances Act. What it does is it separates drugs into different categories called schedules. Based on the schedule is the penalty and the restrictions. Marijuana with an H is Schedule 1, the worst of the worst. These are the strictest penalties. This is the most limited access, very limited access for research purposes, if any. That's why the federal government has controlled the supply for so long and determined who can research it, and why research in other countries has advanced much further than the United States. It's less restrictive now. It's going to be even less restrictive as we move forward, because you can see our little asterisk here. The biggest news in cannabis is that rescheduling of marijuana with an H has been announced, and it is in progress with the DEA. So you can see on this list that hemp is not listed because hemp is not marijuana and it's not scheduled in any way whatsoever. That would, other things that aren't scheduled, or your over the counter Tylenol and things like that. So you can see with marijuana in Schedule 1, this is what the government thinks is the worst of the worst: heroin, LSD, MDMA, peyote, all the psychoactive drugs that affect the way you think. And that might be something the government wants to control. Schedule 2, these are some pretty serious drugs, but they are actually legal and available for prescription. You're not going to get a prescription for powder cocaine, but you might get one for codeine. Um, so then it goes down to Schedule 3, some examples there. It's important to note that Marinol, which is a medicine that's FDA approved, been around for a couple of decades at least, it is synthetic THC, not plant derived. It is totally legal. Marinol is 100% THC product. When you are talking to people who want to regulate the potency and say, oh, it can't be more than 10 or 20 or 30, you can tell them Marinol is 100%. It's pretty darn safe. So then we're moving down the list. I'll go to number 5. And in number 5, we have Epidiolex, which is a CBD medicine. And it specifically was descheduled, not CBD. This is THCBD, not THC CBD, not hemp CBD. Epidiolex was FDA tested, clinically approved. The FDA told the DEA to reschedule it, and they did that. And so at least there is access to that medicine legally by prescription. But this is the framework of what we're dealing with. And so, how do we end prohibition? How do we fix all of this? Well, First of all, we gotta get it out of the schedule. So we either reschedule or deschedule to legalize cannabis, all cannabis. So reschedule means we move it from one to something else. The current proposal is from one to three. That is still highly regulated. It still requires a prescription. It still limits research access, but all of those will be expanded under Schedule 3. So it's good news, but it's not the answer. The answer that we want is descheduling. Move it out of the Controlled Substances Act altogether and regulate it like other legal substances. And we have had a couple of bills introduced in Congress to do this. So it is much broader than just rescheduling. Rescheduling doesn't affect criminal laws. It leaves a whole plethora of things that still need to be reformed. And so we have had the Cannabis Opportunity and Administration Act introduced. Nothing gets passed these days, but it's out there, and I think it's really well thought through. It covers everything. It covers even equity. It does have some taxes. It does have some fees. I don't like that part, but the way it's written, you can tell that the people understand what the cannabis industry needs to be a legal functioning industry. So we want descheduling. And who can reschedule? Can the Health and Human Services Department reschedule? Who enforces federal law? The federal drug laws. It might I may have overlooked that. If anybody wants to throw it in the chat. FDA is going to regulate legal cannabis. It regulates hemp. They like to put out memos. The DEA, yeah, the president. You're right. The president enforces the law, and then we have the DEA, Drug Enforcement Administration. This is an agency within the executive branch. They are controlled by the president. That's their boss. So then we also have other federal agencies. We have Health and Human Services, HHS. So the primary agency is the DEA. Who can reschedule? Well, it's a little bit of a process, but there's some options. So Congress wrote the laws, they can change the laws. DEA, when Congress wrote the law, they said the DEA has the authority to reschedule. So that's how Epidiolex got CBD rescheduled. FDA asked the DEA to do it, and they did it. The other person who can do it is the Attorney General. We don't quite know who that's going to be yet, but the Attorney General does have that authority. They often like to say, "Oh, we can't do that. It's not my authority." They're just full of it. And the other person who can reschedule, not directly, but by ordering the Attorney General and the DEA to do it, is the president. And the president can do that informally, like, I'm your boss, do what I tell you to do. But there's also a formal process where the president asks the Health and Human Services Department to do a research study. And then after that study comes out, that recommendation, they give a recommendation, it goes to the DEA. And initially, the DEA has to acknowledge it and respect it and review it, and then create a response, or then create rescheduling in response to that. And that's where we're at now. We're in the part where the DEA is in the rulemaking process. So they're writing what the Schedule 3 rules for marijuana with an H would be. And then those go to public comment, and then they get amended, and then they go to public comment and get amended. And it's a process that we're looking at going through maybe March or April. So that is, what we're all very closely watching right now. I mentioned the president. We just had an election. We're in a very strange situation where we already had this president, so we know what to expect. What happened under Trump before was that nothing, just completely ignored the cannabis industry. Trump likes money. Cannabis is money. Trump has cannabis friends. They like money. The gray area actually leaves a lot of room for people with power to make money and take advantage of the system. So I wouldn't be surprised if we don't see much changes other than the rescheduling efforts. I don't think Trump's going to be pushing support for comprehensive legislation to change the laws, but I also know there's a crackdown is not coming, and that is a possibility. So same old, except we're on the rescheduling track now. So Cannabis Administration and Opportunity Act, that's the one that I mentioned that I think is on the right track.